Hello, I'm Tara Goodwin, Principal Associate here at Gowling, WALG. Today we're here to talk about the Renters' Rights Act 2025. The Act is one of the most significant changes to the private rented sector in decades. The aim of the reforms are to provide more security for tenants, fairness and improved housing standards for tenants. Today I'm joined by Clive Chalkley, partner, Head of Real Estate Litigation, and we're going to talk about some of the changes within the Act, how they affect landlords, how they affect tenants, and maybe some of the unintended consequences that the Act might provide. So one of the first changes is that there are going to be no fixed term tenancies anymore. So assured short hold tenancies, known as ASTs, are out, and then we're having periodic assured tenancies in. The idea behind that is that tenants aren't going to be granted very short-term fixed tenancies, which means that they're worried about whether they're going to be granted another one, so whether they're going to be able to stay in their home. But on the flip side of that, it also means that landlords aren't going to grant very long tenancies, locking tenants into long-term agreements, maybe at high rents that tenants aren't going to be able to pay.
Yes, this periodic tenancy, it's basically, isn't it, that a tenancy of an indefinite duration?
Yeah.
And it's either brought to an end by the tenant serving a 2-month notice, or the landlord can end it on certain very specific grounds. And I think we'll talk a bit about that later.
Yeah, we'll come on to that later. So from a tenant's perspective, they're quite happy with these changes because it means more flexibility for them. They can obviously end the agreement. It also means that they're not tied in and they've got a bit more security. But in terms of landlords are less likely to be receptive to this change and they're going to be a bit concerned about it. So what are the things that you think that landlords might be concerned about?
Well, I mean, firstly, a lot of landlords obviously use their properties as a safe source of income.
Yeah.
And they think that if they can grant a 3-year lease to a tenant of a good standing, then that's a certainty of income for 3 years. And they may well have mortgages based on this or borrowing of other kinds based on an income stream from a tenant. Obviously, the fact that you can't now grant, say, a 3-year lease will mean that the landlords don't have that security. The tenant at any point can serve a 2-month notice to quit their tenancy. And that's going to have a huge impact on landlords, I think, and their financial planning.
Yeah, do you think it could impact the ability for landlords to get mortgages because they're not going to have an income stream that's consistent, because they may have many tenants in a period because tenants only stay for a short time and serve notice, so they're going to have gaps in their rental income?
Yeah, I think that's probably fair. I think mortgage companies are going to take a really careful look at, the types of agreements that people have got in place and whether or not they feel comfortable lending against them.
So obviously there's going to be a potential impact on landlords' ability to get mortgages and things, but what about in terms of costs for landlords as well? So they have to pay agents' fees, they have to pay to advertise a property. How could the changes affect that?
Yeah, I mean, obviously there are upfront costs for agents every time you have a reletting. So I suspect these changes will mean that because tenants can give short notice to move on, there's likely to be more changes or more turnover of tenants. So there'll be, higher sort of agency fees, sort of final sort of deep cleaning fees, and maybe more wear and tear on properties generally. So I can easily see there'll be sort of lots of additional costs as well rolled up in this.
And is that going to have an overall effect on the market, do we think? So the fact that landlords do potentially have this inconsistent income, could that mean that market rates for properties potentially change or increase?
Yeah, I mean, we've got to see how landlords react to this series of changes, don't we? But I can easily see landlords going, well, actually, my income is not secure via rental property. It is probably more secure in, I don't know, stocks, bonds, or whatever. And I think we could see a number of landlords look to exit the buy-to-let sort of market. And the effect of any shrinkage of supply will be that the remaining supply has a higher demand and therefore rents go up. So yeah, this could, as it were, not work in the tenant's favour longer term, but we'll just have to see.
Yeah, it's a really good point. And talking about rents, I think the changes to rent and the way that rent is reviewed under the new Act is something that we ought to talk about as well.
Absolutely. Obviously, there's sort of two main provisions, aren't there, about rent? The first of which is that The tenant gets to challenge the initial rent within 6 months. So I always think this is slightly bizarre. So a tenant can agree a rent with a landlord, but then within 6 months is allowed to challenge that rent if they don't think it's a market rent and bring a claim to the FTT to do it.
Yeah, and that's quite different, isn't it, to the current system under an AST, for example, where if you entered into a long AST for, say, 12 months at a set rent, that is the rent, and the tenant doesn't have any ability to challenge that rent that they agreed and entered into for that fixed period. The mechanism for challenge, the Section 13 procedure, existed with existing ASTs, but obviously it's now brought in so that the fixed period, because there are no fixed periods, can no longer be protected. So tenants, as you say, from the outset can challenge that within the FTT. Do you think tenants will start doing that? Is that something they're going to do?
Well, I mean, so with the FTT, there's obviously typically no cost consequences for bringing an FTT claim. And okay, it is a hassle. You do have to sort of obviously go to court, but you can do it yourself. So I think that we've seen increasingly tenants challenge service charge regimes.
Yeah.
And I suspect we may well see tenants also start to challenge their rents in a similar way. So I think we'll see more of it rather than less. And I think the no-cost sort of rules on the FTT will really help them, give them confidence that there's little risk in them doing so.
Yeah, and I've certainly seen an uptick in tenants challenging things such as residential service charge, and generally the tribunal's quite user-friendly, and tenants manage quite well without legal representation to do that. So we may well see more tenants going for it, and they've got nothing to lose by having a go, as you say.
Yeah, I think another aspect of it is the idea that you can't build in fixed rental increases. So whereas landlords could previously say, well, year one, we're going to have an increase of 5%, let's say, or year two, another 5%. That's no longer allowed. You've got to, if you want a rental increase, you've got to follow the Section 13 process. So again, you can't future-proof your investment, which I think was we were talking about a bit earlier.
Yeah, it's a really good point. And obviously the process does have to be followed. If it's not followed, or landlords try and get around it by putting a clause into the tenancy agreement, that's not going to work. They do have to follow the process that's in the Act. So it's really worth landlords getting to grips with what they can and they can't do. And obviously increases can only be to market. They're not able to increase based on, this is a really popular property, I've got 20 people wanting it. If it's still valued at market rent, then that's what they can charge. Or if they decide they're not going to charge market rent, they're obviously opening themselves up then to a challenge by the tenant, and from the outset, as you say.
Yeah, it's interesting. I wonder if it's worth having a quick chat about possession grounds.
Yeah, so possession grounds. I think we've all heard quite a lot of talk about possession grounds. The one that everyone's probably seen in the news for years is the ban on Section 21 evictions, the no-fault ground, which is the most commonly used way for a landlord to remove a tenant. Although it's called no fault, it's not the only no fault ground that exists, but it's, if you like, it's a no reason ground. You don't have to provide a reason. You can just say, here's a notice, we'd like you to leave. That's going to be gone, although we don't have a commencement date for that part of the Act as yet. So as of today, 4th of November, we don't have a commencement date for that, but at some point that will kick in, and Section 21 notices will be abolished, banned, and landlords won't be able to use them. So landlords are going to have to think about how they're going to remove tenants from properties if they need to. Obviously, if there is a fault or the tenant has done something wrong, they're in rent arrears, there are grounds to deal with that. But what's quite interesting is, what about if a landlord just wants the tenant out for a particular reason? What are the options?
Yeah, so obviously there are a couple of grounds, aren't there, that are, I would still say, are no fault on the tenant's part. So, for example, the landlord wants the property back because he wants to sell it or he wants to live in it.
Yeah.
Those are still grounds available to them, but they're quite strictly monitored, aren't they? Because if the landlord gets back possession of its property on the basis it wishes to sell it, then it's got to sell it. And now it may well be that the sale falls through.
Yeah.
But But in either event, the landlord can't re-let that premises for 12 months after it's evicted the tenant.
Yeah, which is a really interesting point, and that obviously goes down to trying to provide more security for tenants, but it's obviously providing less flexibility for landlords to deal with their property as they like. It's interesting to think about how that's going to be enforced. So obviously when you rely on a ground, you're going to have to prove to a court that you satisfy that ground. So in the example that you've given, a solicitor's letter, an estate agent's pack, something to show that you are selling the property, you've marketed the property. But if the property is then removed from the market because the sale falls through or the landlord can't sell it, changes their mind, who's monitoring the 12-month process? And I think that's something we're not yet sure about, but it will be something that we'll have to see how that's going to work in practice and whether it's something that is going to be monitored and how it's going to be monitored.
Yeah, that's interesting. I mean, what worries me probably most about this whole process is that the courts just aren't equipped for a lot of possession actions. I mean, we are typically seeing very long delays on residential matters, and the county courts are overburdened as it is. You know, we've definitely got examples where you don't see possession for at least a year. And those kind of circumstances, especially if there are fault grounds going on, you can see that that's a huge problem for landlords.
Yeah, and I think that's true, isn't it? Because the way the courts list possession hearings is, 10, 20 matters are all listed at the same time for a possession hearing, but we've obviously got new grounds for possession, which everyone's got to get to grips with, including the courts and the judges. So inevitably, some of these hearings where we've got a new ground that we're not quite entirely sure about how it works is going to take longer. And so it might mean that, hearings get moved or the whole process just takes a lot longer than it should. And the impact is going to then be on landlords, isn't it? Because they're not able to get possession back and do whatever it is they were planning on doing with the property.
Yeah, I think that's right. So, I mean, I guess if we sort of draw all these strands together, obviously we've only talked about 3 aspects of it. There are a lot of other aspects of the Act, right to request pets and, all sorts of other things as well. But what's your take on, what you think the overall impact's going to be?
I think landlords are going to be very concerned about the implications of the Act, particularly on them. I think smaller landlords are likely to be more affected because they're more sensitive to things like changes in income or inconsistent income and getting the points we talked about earlier about getting mortgages, having to pay agency fees. That is going to affect them a lot more. So I think potentially we're going to see some landlords deciding to withdraw from the market. I also think there could be, because of the inconsistency, landlords that stay in the market, rents potentially may increase. And although there's a ban on high rents, or not a ban, but they can be challenged by the tenant, I think market rent may increase, and that's obviously not what was intended with the Act. It was intended, to increase the fairness between the parties. But I think what maybe was unintended is that it may result in market rent increasing and therefore tenants paying higher rents than they were paying before the Act.
Yeah, I agree. I can definitely see landlords beginning to move out of the market as their investments don't look as sure as they were before, which will only increase the demand for the current stock.